Here we are again. This time, chapters 9 and 10 of Gifford will be our focus. And as typical, I'm going to skim through them and point out some highlights and some of my own perception of some of the issues. So I won't be just simply rehashing Gifford. And this video will be shorter than some of the others. I know in the first two or three are fairly lengthy, and I apologize for that. These will be much briefer. Multi-party negotiation and negotiation counseling are the two topics in this unit. I don't have a great deal to tell you about multi-party negotiation. Some of it I may have even mentioned already. If some of this is a rehash, it won't hurt you to hear things again. If it is a rehash, forgive me for that, but pedagogically speaking, it never hurts to hear something more than once, and in fact, that is a typical method for trying to reinforce information that you want students to gather, is to tell it more than once. Might as well throw out one of my favorite phrases when I teach negotiations classes, and that is, questions unasked are questions unanswered. I know I've said that to you more than once, and I'll say it again. One of the most powerful weapons you have as a negotiator is the question. One of the most powerful questions you can ask is why. So keep those two things. Those have nothing to do with what we're going to talk about right now, but they bear repeating because you'll find yourself using in good stead in using those two things, questions and particularly the question why. What about multi-party negotiation? When you find yourself in a situation where you have multiple parties, in other words, you're not negotiating with just one other party, there's obviously three or more would be multi-party. Typically we're thinking of a volume here, but it could just be three. One of the things that occurs is that you end up with coalitions oftentimes. And coalitions meaning what? Meaning some group of the negotiators gather together and form something of a negotiating unit, if you will. And so this might be a bunch of smaller parties negotiating against a larger party, for instance, possibly, although we'll talk about whether that usually happens or not. Or it could be that you've got multiple countries, for instance, negotiating. If you ever read Getting to Yes, they talk about the mineral rights at the bottom of the ocean and countries coming together and trying to negotiate how that's going to work out. It's pretty interesting reading. So what happens with coalition building? Well, ironically, maybe not, the less powerful parties tend to band together against the more powerful party. At least that's what the evidence and research tends to show. Presumably, if you're the more powerful party, you'd like to pick off some of those weaker individuals and get them into your side. And so, but regardless of how that works out, some way or another, people are going to choose sides. We just do. It's just part of our human nature, part of that fallen nature that we have. When do coalitions fail to form? I mean, because let's assume that we can assume that coalitions will take place when you have multi-party negotiation. It's an inevitability. You just think of any instances when you've had situations where there were multiple people involved in any effort of any kind, doing anything. Inevitably. I mean, let me give you a really simple, trite example, but you will, as soon as I start saying it, you'll go, oh yeah, I've been there. This is typical, right? You and a group of friends, 5 or 6 friends, you go to a football game, a movie, an outing of some kind, whatever it might be. You're at church, whatever the circumstances are, and you decide that after the event, whether it's a sporting event, a movie, church, whatever, you want to go out to eat. Now, see, some of you are already going, oh yeah, I've been there, man. I know what, and what happens? Well, you're trying to decide where do you want to go to eat, and you've got 8 people, and everybody has their own tastes and preferences, but what inevitably happens is one of two things, right? one just sort of domineering person just says, well, we're going to go to, zippity doodahs. And that's where you go, because that one person is just so domineering. They're just able to get everybody to go. And everybody's kind of like, and other people don't care. But that doesn't always happen, does it? And as often as not, that person isn't there. And you got a bunch of people like me, you kind of wafflers. You don't really care that much where you go. You got places you'd prefer not to go. I don't like Chinese buffets, for instance. So I prefer not to go to the Chinese buffet. But if everybody else wants to go, I probably will give in. And it may say something about my negotiating skills sometimes. But in non-preferential matters, right, we don't care. We can let those go for the most part. But you understand coalition building when you start going, well, I know Joe doesn't like Chinese buffets, and I don't either. So I'm going to go get Joe to say no to Chinese buffet. I'm going to run over, hey, Joe, let's form a coalition against Chinese buffet. You kind of start to see how that happens, and people start to gather together with their own preferences. You know what I'm talking about, right? And so this is the same kind of thing when you're talking about coalition building in a negotiation. It's not really any different in any significant way. So how might coalitions form? Well, the parties have identical interests or similar interests or very close interests. This would happen to me frequently in cases where maybe I was defending someone. I had maybe there were 3 defendants. And while we might have been sort of pointing fingers at each other in terms of who done it, we were all focused in on maybe this particular plaintiff's case was one in which we just simply didn't believe the plaintiff was really injured, or they weren't injured the way they claimed they were injured. And so we were all sort of focused in on hammering away at the idea of it's not much of an injury here, and less concerned about beating each other up. So that might be an instance where we have similar interests. What else? The parties may need each other because there is a clear and overwhelming power of a third party. I hearken back to Richard Nixon, who had the idea, and as many politicians do, the enemy of my enemy is my friend. And that's kind of what's going on here. You may or may not like your coalition partner, but you may feel that you have no other choice because the overwhelming power of some third party just seems insurmountable unless you can gather enough people together to really beat them down. What else? Sometimes coalitions form just out of sheer irrationality. People can be irrational, I hope at this point, if you're a law student or an MA student, you know that people sometimes behave irrationally. That shouldn't shock you. Well, guess what? Sometimes people form coalitions just because they're irrational. There's no real reason, but they do anyway. There's nothing you can do about that. You're just that's a toughie to deal with. What do you do when you have a multi-party negotiation? Well, if the parties are sufficiently numerous, it's probably a good idea to set some ground rules and for everyone to actually pre-negotiate, if you will. Hey, here's how we're going to conduct ourselves. Have some basic ground rules. I mean, maybe you have a third party come in as a referee of some sort, a mediator, whatever you want to call that person who comes in and kind of gets everybody together. If the parties are really numerous, and I don't know what the magical number is there. It kind of depends on the parties, I suppose. But if you have 50 people negotiating together about something, the odds are you're going to need some written guidelines on how things will work. It's probably otherwise not going to be doable. At what number do you no longer need written rules? I don't know. I just don't know. 3 certainly can be done without any written rules, without any real formal rules other than just general politeness. 5 may be still okay, even just under the sort of general politeness theory. Hey, we're just all going to be polite with each other and try to resolve this. When you get to 10, are you at the point where you need written rules? Maybe. Maybe that just depends on who's negotiating. I don't know. And so that'll be a function of the people that are negotiating and whether they know each other, don't know each other, how well they know each other. Can they get along? Can they not get along? Do they need some formal structure for other outside reasons? such as deadlines imposed by either legal matters or contract or something like that. The last thing that I will mention with regard to multi-party negotiation is something I think I've brought up before, but I'll mention again, and that is the idea of a single party text, or a single negotiation text, I'm sorry. And the idea behind that is that if you have a document that is going to result from the negotiation, one party goes ahead and prepares a document for everybody else to look at. And then people make changes and suggestions, and it really can be very helpful because it gives everyone a place to start. And there's lots of things that everybody may realize, we don't need to negotiate all these fine points or these small points because they really aren't very important. What we need to get fixated on are the big issues. And it may help to get people focused on the larger issues, realizing once you see it in writing that you don't really care whether the lease starts on January 3rd or January 1st, for instance. It may just not be, the contract may not, whether it starts on a 1st or a 3rd or a 15th, or whether payments are due on the 10th or the 12th or the 18th, those kind of things may be immaterial, but the amount of the payment may be very material. So that's a thought. One of the good things about it is that it gets everybody focused. All right, Chapter 10, negotiation. That's it for Chapter 9. Chapter 10, negotiation counseling. Basically, we're talking about the interaction between the attorney and the party as the negotiation is going along, and what kind of things. This happens all throughout the negotiation, from the beginning to the very end. It even starts before there's any negotiation going on at all. I want to tell you a little story about this. I will refer you to the movie A Few Good Men. I don't necessarily recommend you watch the whole movie, but there are some good scenes in that movie related to negotiating. If I can pull up the scene that I'm thinking of somewhere on the YouTube or something, I'll post it, or I'll post a link to it. There's a scene in that movie, A Few Good Men. Tom Cruise plays an attorney. He is a Navy attorney who's defending two Marines who have harmed a young enlisted man as a result of an order given to them called a Code Red. The idea of the Code Red was to sort of scare a Marine into behaving more like a Marine. And so these two young enlisted fellows, a sergeant and a corporal, I believe, or corporal, no, I'm sorry, a corporal and a whatever is less than a corporal, they went in and they kind of roughed up this Marine. Well, the Marine ends up dying, and they're charged with murder, and among other things. And Lieutenant Caffey, who is the defense attorney appointed by the military, gets a deal out of the prosecutor. The deal is that these two fellows will plead guilty, and they will serve 6 months in Leavenworth. As part of the deal, he goes and he tells the corporal, who's kind of really speaking for both men. His name is Harold. And he says, look, you'll get out, you'll be in and out in 6 months in good behavior. It's a hockey season. Hey, right? That's all it is. Just a hockey season. Unfortunately, Caffey hadn't really spent enough time getting to know his clients. And Harold, Corporal Dawson, basically tells Caffey to shove it. He's polite because Caffey's an officer and he's an enlisted guy. And he believes in respecting the officer, at least officially respecting him, even if he unofficially thinks he's a loser. And so he very politely and respectfully tells him, no, thank you. We can't take that deal. And they can't take it because of their honor code. And Caffey doesn't really understand the honor code because he hasn't bothered to spend the time counseling his client. He just got the deal and thought, this is a great deal. Any sensible person would take it. Well, guess what? There's that irrationality problem. I'm not saying it's irrational to have a code. Don't misunderstand me. I'm saying that they didn't behave in the way that Caffey anticipated they would behave. So it became a problem for him. because he hadn't counseled his client. He hadn't entered into any discussions with his client in order to get to know the client. So keep these things in mind. Rule 1.2, you control the means for the most part, but the client controls the ends of the negotiations. So keep that in mind, attorneys. You've got to keep the client informed. You've got to, right? Rule 1.4, you have to let the client know what's going on at all times. And rule 4.1, you just got to tell the truth. And I can't emphasize this enough. I know one attorney here in Kentucky who has advised his young nephew who's thinking about going into law. He told him to go get a seminary education first. And his nephew says, well, why would I do that if I want to go be a lawyer? Well, that kind of seems kind of crazy. And he said, you know what? Teach you a lot about compassion and mercy, which are sadly lacking oftentimes in the legal profession, as well as it'll give you a very stout understanding of telling the truth and being honest and forthright, which this lawyer apparently thinks is lacking in the legal profession. I don't know that that's the case. It's not been my own experience for the most part, fortunately, but nonetheless, these are things that you've got to keep in mind, right? I think that Gifford, and I will comment on this a bit, I think Gifford overblows a little bit the lawyer's tendency to dominate counseling. He's making a valid point that you have to be careful. Sometimes clients will say, well, what do you think? Would you do the deal? Would you take this deal if it were your situation? Personally, I think it's okay to say, well, yeah, I would, or no, I wouldn't. I think you have to let the client know, though, listen, maybe you're super risk averse and you say, look, I don't like taking any gambles of any kind ever. So I would take the deal. But having gotten to know you, you're a little bit more of a risk taker. Maybe you've got a business person who is an entrepreneur. And entrepreneurs, oftentimes they're broke one day and they are just rolling in dough the next day, and then they're broke again the next day, and they're rolling in dough again. I mean, that's the way some entrepreneurs are. They're just up and down. And so maybe you say, look, if it were me, I'd take this. But I don't know. You take risks. Your risk tolerance is a lot higher than mine. So maybe you don't want to take this and try for something better. You got to know your client. When do you discuss or counsel your client? When do you counsel your client? All the time. At every moment during a negotiation, you will be discussing alternatives. Even remote alternatives should be something you discuss. Now, I'm not talking about absurd alternatives. I'm talking about remote alternatives. Alternatives you think are unlikely but are still within the realm of possibility. If your client has a strained pinky because of a car accident, it's probably not a good idea to be telling your client you think they're going to get $1 million. That's probably not, and there's no need to counsel your client on what to do if they get an offer for $1 million. It's just not going to happen. You know it. I know it. Most clients actually will know that. So you would be careful there about counseling that. Consider the advantages and disadvantages of each alternative, and this is going to sound sort of familiar, I think, to some extent. You're going to say, well, haven't we already talked about this stuff? Yeah, we have, but again, I'm going to repeat myself because at the risk of boring you a little bit, it'll serve a function, and that is that you've heard it again, and it's never a bad thing. Reach your decision with and not for your client so that you can maximize your client's interests. What does that mean? Well, some clients will say, hey, whatever you want is okay, or whatever you think is best is fine. Try to draw them in a little bit with you on that, even if you think they're probably right. I should just take care of it because they're going to botch it anyway. Go ahead and draw them in and say, well, this is your deal. This is your circumstance. You need to be involved. I understand you feel confident in me, and I appreciate that, and I really, I thank you for that. Nonetheless, I still think you need to really make sure you feel comfortable with this, and I'm still going to pester you about it. I'm not simply going to make a decision for you. I'm still going to tell you what's going on. Even if all you are going to do is rubber stamp what I'm doing, that's fine. I still need your rubber stamp. And just let them know, and so that they're part of the process. They'll feel a lot better about whatever result arises if they're part of the process. We talked about for a minute there about telling your client what would you do. I would just say to reiterate, I think that's okay. Just don't overdo it. Like, oh yeah, this is the greatest deal ever. When you start to sound like a used car salesperson. Uh, we have a guy here locally. He's the man of the people. That's a used car guy. He's a man of the people, and he's always, yeah, this is what I would do. Yeah, that's probably pushing it too far. Uh, how do you make sure that you don't overwhelm your client? Well, remember that the client is ultimately in control of the process. It's their case, it's their circumstance, it's their deal, and just let them know that it's your case, it's your deal. I need to make sure you're on board. You understand this is where we're headed. I think it's a good idea, but I need you to be sure you feel comfortable with it. A lot of times it's a good idea to say, think it over for a day. Make sure they're good, or think it over for a while, or a couple hours, or whatever they feel comfortable they need. Uh, Even if you think that what the client wants to do is a bad idea, if it's not illegal and it's not, I would say if it's not immoral, I mean, I'm not going to counsel my client to do something that I think is immoral, probably because in a large number of instances, it's probably likely to be illegal as well. Or if it's not illegal, it's going to be very close to being illegal. It's going to be some serious question, some very gray area there. So if it's illegal or immoral, if it's illegal, obviously you can't counsel your client to do it. If it's immoral, and by immoral, grossly immoral, I would certainly strongly urge the client to take another course. But take a deep breath, because if the client just wants to do something boneheaded and they're insistent, there's really nothing you can do. And you just kind of have to say, well, I think you're making a big mistake, but if this is really what you want, okay. A good idea there, hint, hint, write it down, send them an email, send them a letter, whatever. Make sure that you have documented whenever you think your client is getting ready to make a bonehead decision. Make sure you've got it documented so that it's very clear that that you've told them you think it's a bonehead decision. Always be reasonable and rational in your approach. Give your client lots of feedback. Take a moment to be as objective as possible. Make sure you haven't invested so much that it's become personal. I've seen attorneys do that. When do you have a counseling session with your client? Before you negotiate, while you're negotiating, whenever there's a significant turn of events in the negotiation, whenever there's a substantive decision to be made in the negotiation, when you have a final deal for your client's ratification, or whenever you think as the attorney that it's necessary. So pretty much any time and all the time throughout the negotiation is a good time to counsel your client about what to do. All right, well, that takes care of that session, and chapter 11 and 12 will be even, well, I won't promise you it'll be shorter. We'll talk about negotiator identity and just a word or two about alternatives to negotiation.